Everyone, it's Ann Searing here, and I'm going to go ahead and get started with our session on the Open Meetings Act and the Freedom of Information Act. This is the third webinar we have done, and the goal of these is to provide a basic information to library trustees and obviously library staff as well. One thing we wanted to reiterate again, the webinar sessions are available on our firm's website after the session, so if you have board members or other staff that did not find this time convenient, he or she can listen in at any time they want by just looking at or going to our website and filling out a simple form, and we'll send a follow-up email after the session with that information on it. And I apologize, at the last webinar, if you attended, we were planning on doing a Library Privacy Act session, and I realized that I'm presenting one at the Michigan Library Association conference at the end of the month, and so I didn't want to double up on the same topic twice in a month. But for those of you who cannot attend the Michigan Library Association or can't attend that session at the conference, I'd be happy to do another webinar next year on that topic, so we can certainly provide that information in webinar format as well. What I want to do today, though, is talk about the Open Meetings Act and the Freedom of Information Act. And these are two very important pieces of information. And my goal of this session really is to prevent any library, any public body from getting themselves into a situation where they are in violation of these two acts. Based on my experience, the violations are typically always accidental. And a lot of times, especially with the Freedom of Information Act, a library may find itself in violation of the act because it was trying to be nice or be accommodating to a requester. And so, libraries are in a service industry, and that's one of your goals is to provide good customer service. But I want you to think about when you're thinking about the Freedom of Information Act, as I'm going through it, I'm going to point out situations where I want you to think about being very very proactive and very specific with what has to be in a response and how you respond to these requests. So we're going to cover the Freedom of Information Act first. My slide is not moving for some reason. I apologize. Oh, there we go. Sorry about that little technical glitch. Under the Freedom of Information Act, there is a provision and a definition of who may request a public record. And the Act defines any, quote, person has the right to inspect, copy, or receive copies of public records. The only person that is not included in the definition of person, and we mean no disrespect by this, is just right from the definition, is any person that's currently serving the sentence of imprisonment in a state or county correctional facility in this state or any other state, or in a federal correction facility. I think they found that before this amendment was made, this amendment was not, this was not in the original act, but the people with, who were incarcerated who may have a lot of time on their hands tended to send a lot of Freedom of Information Act requests. So the act was amended. So basically, if you get a request from a company or a corporation or a person, you have the same obligation to respond. It doesn't matter whether that person even lives within your geographical service area. What must the request include? And this is one of the things, I'm going to give some practice pointers along the way. The FOIA is a very pro-requester statute. Okay, so anything that may, side with the person making the request, the courts tend to err on the side of caution with respect to the person who is making the request. And the first thing that they've done, I think, is that they've specifically not clarified that there has to be any specific information or statement in an initial request. For example, you do not have to say in a FOIA request that you're asking this pursuant to the Michigan Freedom of Information Act, for example. Okay, it's any request in writing. So if you receive an email from a constituent, let's just say it's a complaint email. And the complaint goes on for a paragraph or two, and then at the end of the complaint they say, by the way, I would like a copy of the library's patron behavior policy. That is technically a Freedom of Information Act request. A request is any written request for a document. So if someone comes in, the same situation comes in and complains to someone, let's say at the circulation desk, and then at the end says, I'd like to see a copy of your personnel or your patron behavior policy, a verbal request does not fall within the Freedom of Information Act. Also, one thing to know is that the FOIA, under the Freedom of Information Act, a person has the right to inspect, copy, or receive public documents, okay? What this means is that and that decision is in the hands of the requester. If they send you a Freedom of Information Act request that says, I want to receive a copy, you're obligated to give them a copy. If they send a Freedom of Information Act request that says, I want to come in and inspect the documents, that's their right. They have the ability to inspect or receive copies upon their request. One of the things that the Freedom of Information Act also states is that a requesting party may submit a continuing request for public records that are created, issued, or disseminated on a regular basis. And the request can be made for up to 6 months and may be renewed. Libraries don't get this as much, but one common request you may get that would fall into this is if someone wants what this is called as a subscription, a 6-month subscription for your board minutes. And what you can do is require a deposit up front for the reasonable copying costs of that. But if they submit a request for this information, then you have to honor that as long as it's up to 6 months, and it can be renewed. If it's not created, issued, or disseminated on a regular basis, then it's not properly the subject of a subscription. For example, if maybe patron incident reports, although you may have several of those within a time period, they're not something that are created on a regular basis or issued on a regular basis, like meeting minutes. And so those are the things that you may talk to your attorney about as to whether that should fall under that subscription request. Again, in this bullet point here, talks about it doesn't have to be a formal written letter. It can be made in the form of an email or a fax. One of the things I want to spend a little bit of time talking about is what is a public record, because there's going to be a two-part decision that you're going to make upon receiving a Freedom of Information Act request. One of the decisions, the first decision you're going to have to make is this something that falls within the definition of a public record? As you can see, they've talked about computer software is not included in a public record. But there's been a lot of discussion, and this comes up a lot in the realm of email. If I'm sitting at my desk at work and I send an email to my sister arranging, a dinner, or, telling her I'm going to come over to her house this afternoon, that email, although it's made and created on a public computer system or at a public computer, it's still a personal email. It's not used or retained by the public body in the performance of an official function. If on the same token, if I'm the director and I send a response to a patron using my public computer, obviously that is a document that was used in the possession of or retained by a public providing the performance of an official function. Keep this in mind if you regularly do work from home, because the court is going to look at the nature of the record and not where and when it was created. So if you do something at home on your personal computer and it's at 9 o'clock at night, not during your normal work hours, if it is something that you're doing as part of the performance of an official function of the library, that document will still be considered a public record. So keep that in mind. If you do work at home, make sure, for example, that you're keeping those, printing those, or retaining those in a way that can be easily identified should you get a Freedom of Information Act request in about a particular subject. And there was a recent case that found that public records do not include private email correspondence, even if it was sent or received on a public computer. And they give the example too of, you know, documents that may be found in your desk. You know, just because you bring, you know, a piece of private correspondence to work and put it in your desk does not turn it into a public record. When we talk about email, and I want to talk about that a little bit, because the most I guess the biggest, I guess, increase in types of requests that we're getting is requests for any and all email on a certain subject. And we've received requests that of emails that cover, you know, months and months and months of correspondence. And, you know, I can get up to 100 emails a day, for example. And if you are in the same situation, you want to make sure that you are keeping your record retention policies in mind when you are, you know, keeping or deleting those emails. Because if you're keeping those emails in conformance with a policy, then you want to make sure that you know how they're kept and where they're kept. If you are not keeping your records in conformance with a policy, you know, you may have emails, you know, volumes and volumes of emails that are in your system that you don't need or should not be retaining. And if that's the case, you're going to have to go through all those documents in order to sort through the records that would be responsive to a FOIA request. So again, dust off your record retention policy and take a look at it and figure out how you are supposed to deal with your correspondence. These are just some of the kind of the rules of FOIA that I want to talk about. We talked about the ability already for the person to inspect documents, and in conjunction with that, the public body must furnish reasonable opportunities and facilities for inspection and examination of records. So what that means is basically if someone wants to inspect documents, you have to find a place for them in the library where they can do that. Typically, libraries are not places where that is too much of a problem with your meeting rooms and otherwise, but for those smaller libraries where space may be an issue, think about that in case you get a response for an inspection. One thing FOIA does not require you to do, I mean, there's a lot of stuff in FOIA that tells you what you do and when you have to do it, but FOIA does not require you to make or prepare any particular records that the library has not already created. And I want to talk a little bit about that because I think it's kind of nuanced. As we go back to the same theme, the courts are really going to look at, sit in the position of the requester and think, well, what's reasonable for the public body? For example, let's say that your request is for the average hourly wage of library employees. Okay. If you don't have a document that has that information already created, you are not required to go through all your employment files and look at all your hourly wages and make a new public record that gives that information out. Okay, so you're not required to create a record that would respond to that request. You may be, depending on the type of situation. For example, if it's pretty readily apparent, if you have a document that lists what the hourly wages of all the employees are, you may have an obligation to turn over the underlying information, the underlying facts that would allow the requester then to make that calculation. But again, you're not required to create particular records that have not already been created. Similarly, but a little bit different, you're not required to create a compilation, summary, or report for a requesting party. For example, this wasn't a library, but a township we were working for had a request for this person wanted to summarize all the laws that allowed that particular township to charge this particular tax to the individual on their property. And again, there's you're obviously not required to do legal research. There was no requirement that they create a compilation, summary, or report for the requesting party. Again, even if you would create a compilation or summary or report, that's not necessarily wrong. Some people volunteer to do that. That should be done, with a lot of forethought, because especially if you have what I refer to as serial requesters. There's some people that just keep requesting and requesting and requesting. You may create an expectation that you're going to do this extra work. Also, sometimes people want to either prepare a separate new public record or create a compilation in order to avoid giving out the underlying documents. If the request would also cover these underlying documents, you are not relieving yourself of an obligation of turning over the underlying documents by creating, for example, a summary of them. Okay, so if you have a question or concern about that, please ask your attorney so that you don't get yourself into a position where you are going to be in violation of the Freedom of Information Act request. You are allowed to adopt reasonable rules to protect your public records and prevent excessive or unreasonable interference. One thing we do recommend is to have a Freedom of Information Act policy. I want to talk to fees because aside from the fee issue, you're not required to have a FOIA policy in order to respond and adequately, identify a FOIA request and respond to it. The one thing you do have to have a written policy for is to charge one type of fee, which I'll get into that in a little bit. But again, a FOIA policy also sets up reasonable rules for the, excessive and unreasonable interference with the discharge of your function. So again, one of the rules may be that you set up inspections during business hours. One of them may be that you have one particular person assigned to do the FOIA inspection work, so that that person who's inspecting documents doesn't keep interrupting the director or assistant director or so forth. So things to think about, especially if you've been through a process of what's reasonable and what would protect the public records. One thing that is kind of hidden within that is that if requested, a public body is required to provide a certified copy. And what we've done is we've actually created, some people have stamps that have certified copy, and the secretary of the board will certify that it's a particular copy of something. We've also developed some language that we've done to attached to a huge FOIA response that basically says the attached documents are all certified by the secretary of the board or by the library director. So again, if someone's asked for a certified copy, make sure you respond to that requirement to make it a quote-unquote certified copy. Who is the FOIA coordinator? They added this, it was probably 15 years ago, the responsibility to have a FOIA coordinator. And I think the reason they did that is just so that, for two reasons. One, I think if you are requesting, you're not required to look up, for example, if I'm going to send a request to a library or another governmental agency, I'm not required to look up to find out who would respond to it or call the library. I can just address that request to the Freedom of Information Act coordinator, and it should get to the individual who's designated by the library to accept and process the request for public records. Typically, the FOIA coordinator is the director. You want to make sure that it's somebody that has a good handle on all the documents and where they would be. It's also someone who is in the library on a regular basis in order to respond appropriately to these requests, because you are under a timeline, which we'll get to in a couple minutes. And written requests must be retained by the public body for 1 year, and the FOIA coordinator is responsible for keeping a copy of the request. My kind of practice point recommendation is not only to keep a copy of the request, but also keep a copy of every document that you respond to, even if you just scan it in and keep it on your computer if you don't want to keep a hard copy. It has come down to, in cases of, did you release this particular document, and if not, why? So in order to defend yourself in the event that your library gets into a situation where you're in court, you want to make sure that you know exactly what document you gave out and when. So the library does have an obligation once it receives a Freedom of Information Act request. Okay, a public body must respond to every request. And you have 5 business days to do that. And 5 business days is Monday through Friday, and it excludes holidays and federal holidays and, obviously Saturday and Sunday. It's 5 business days regardless of how many days you are open. So if the library is only open on Monday, Tuesday, Wednesday, and Thursday, you still have to count Friday in your time period for responding to the FOIA request. So again, it doesn't matter how many days your particular library or business is open, it's 5 days, 5 business days from the date of the response, okay? If you receive it by fax or email or some other electronic transmission, text or anything they're going to come up with these days, the request is not considered received until 1 business day after that transmission is made. So typically you think of this in a calendar week. I do, because 5 business days is obviously a calendar week. So if I receive it in the mail on Wednesday, I know that I have to respond by the next Wednesday, unless there's some federal holiday in the middle. If I receive it by email and it was sent on Wednesday, it's not considered received till next business day, which is Thursday. So my response is not due until the following Thursday. So again, think of, are there any holidays, in that 5 business days, and how was the request sent to you, because you may get an extra day depending on how it was sent to you. FOIA actually, although it's really contained in different parts of the statute, I want to give you on one slide your 3 options that you have upon receiving a request, okay? So you receive a request in the mail. What are the 3 things you can do within that 5 business days, okay? One of the things you can do is grant, deny, or grant in part or deny in part. And the statute says that any denial must be in writing. So technically, if you grant a FOIA request, you don't have to do that in writing. You could just send them the documents or what have you. I recommend that all correspondence be in writing, which gets me to the point of where I want to point out what I think is typically the #1 mistake that public bodies make in responding to Freedom of Information Act requests. What happens is you get a FOIA request and you call that individual and ask them for more information. Or, you attempt to make some sort of contact with them, asking them to clarify what their request is for, and you don't hear back from them. Okay, if within that first 5 business days, that's not necessarily a bad idea. You may try to contact them, discuss it with them. There may be some things that you can find out from them. But if the requester doesn't respond to you, or if you don't get an adequate answer to your question, you still have to do something in writing within those first 5 business days. So again, take advantage of one of these 3 options. If it's a voluminous request that's going to take many hours to fulfill, and if it's a large volume of documents, my recommendation is to follow option #2. And you can request a deposit up to 1/2 of the good faith estimate of the total amount if the request is over $50. So let's just say they ask you for all the directors' emails, to and from board members or something like that for the past 6 months. Well, depending on the volume of that, it may be hundreds and hundreds of emails. And likely, if that request is going to be in total over $50, you can ask for a deposit of 1/2 of it up front. And the reason that you want to do that is that you're not required to further respond to their request until you receive that deposit. And this is one of the options we use when we feel that there's somebody that's on a fishing expedition, or, I hate to say it, I'd like to think that everyone who uses FOIA is using it really because they want to see the inner workings of government. But a lot of times it is used for nuisance purposes, or, to quote, dig up dirt, or to find, information that, may or may not be directly relevant to what's going on. So if you figure that, and this is one way to test whether the person's seriously interested in the information, because if they're not willing to pay the deposit, then obviously they wouldn't be willing to pay for the total cost of the ultimate request. And we've had municipalities that unfortunately have decided just to process the request without getting the deposit. They've had like reams of paper that they've used to copy and spent 20 hours doing a request, only to have that paper sit on the counter waiting to be picked up for months or never to be picked up. That has happened. So that's one thing to consider when you're talking about a deposit. You can also send a notice of an extension for up to 10 business days. The notice must state the reason for the extension and the date by which the board will respond to your request. These are actually two things that are contained in the statute. So any extension letter that we do says we're extending it for 10 business days. The old statute used to say that it's for exceptional reasons, or used to have some unusual reason to extend it for 10 business days. That was actually eliminated from the statute. So now really the library can send the notice of up to 10 business days, but you must state the reason. Typically we just say we need time to fully review and process the request. So that can be the state of the reason, but again, you have to give the person the date by which the board will respond to the request. So, typically my extension letter will say we will, grant, deny, or grant in part and deny your request by, that date. And that date is typically the 10 business days plus the initial 5. So if you calculate that date, you should, it's 3 calendar weeks, give and take. If there's no if there's no federal holiday in between, it's 3 calendar weeks from the day you receive the request. Again, it's not, if it's sent by email or fax, you get 1 extra day, but it's 3 calendar weeks. So that's something that if you're confused about the timing, really typically I'll go through when I get an issue like this with my clients. I'll kind of go through how you calendar it, maybe once or twice, and then it's really easy to pick up on. So it's something that if you have questions, certainly ask about it, but it gets pretty routine after you've done enough of them. Okay, so I want to talk about what can be denied. All right, certainly if the document does not exist. If the document does not exist or cannot reasonably identify it, then you can certainly deny the request on that basis. What the library, and I may get to this in a later slide, but it bears, it's certainly worth repeating. If you deny it because it does not exist, you have to certify that it does not exist in a name known by the library or a name known that is reasonably known to the library. And we have some certification language that we don't provide a separate certification. What I typically do is say, the document, we do not have or maintain this document. And this letter certifies that the library does not have or maintain the document as named by the requester, or that the library can reasonably identify as being subject to the request, something to that effect. So make sure that you have some sort of certification in that. Again, the trickier one is if you have a document that responds to the request but it's not considered a public record. If you remember going back to that slide where I talked about the definition of a public record, for example, I do not believe, and this is my opinion, you should consult with your attorney about it, but typically notes that are taken by somebody at a meeting that are not used, not circulated, and not used in the performance of an official function, but are used solely to recollect, or to use it to refresh that person's individual memory, a lot of times those aren't considered public records. So while you may have the document, it's not going to be fit under the definition of a public record. So you may, if you have a lot of documents in that category, especially if the person kind of knows that they're out there generally, you might want to talk with your attorney about how to handle that within the response of a FOIA, within the actual FOIA response. And as we stated before, if we don't have the document, again, we'll say the library doesn't exist, we may also notify them that you're not required to create the document. So if it's something that the person, you may think that the person thinks that it's something you should have, you say, we don't have the document and we're not required to create that document. That might be a little extra bit of information that you may choose to pass on to the requester just so that they know what is subject to the request and what is not considered a public record. Certain documents are exempt, and all records are subject to disclosure unless they're specifically exempted. There are 24 types of documents that are exempt from disclosure, and I'm going to give you some of the typical ones that may be encountered by a library. So information that's exempt by statute. I want to talk about this in particular because the Michigan Library Privacy Act is one of those statutes that specifically exempts information from FOIA requests. So patron records. records of internet use. I say consult your attorney on video surveillance because in my opinion, you know, depending on where it is, my general rule of thumb is that video surveillance would be subject to the Michigan Library Privacy Act, because the definition of a library record would include something that personally identifies a library patron. So if you've got their personal image captured on video surveillance, then in my opinion it would be information that's exempt by statute. There's also a general privacy exemption under FOIA, and this one applies not just to libraries but to every other public body in Michigan. And that's information of a personal nature where the public disclosure of the information would constitute a clearly unwarranted invasion of an individual's privacy. You may encounter this in requests that don't involve your patrons, because patrons are sort of an easier, because you have the Michigan Library Privacy Act, but issues that may involve your employees. I want to be really careful about that because typically the personnel policies or personnel records of a public body, including a library, are subject to disclosure. There's a Michigan Supreme Court on the case on the subject. So typically information that's considered part of your quote-unquote personnel file may be subject to disclosure. With that said, if there's certain pieces of information in that that's personal, that may constitute clearly unwarranted invasion of that person's in privacy. For example, if a reason for absenteeism may be family issues or something like that, that information may be able to be redacted from a FOIA response, and I'll get into that a little bit later about what you can take out. Bids or appraisals, but only for a certain period of time. Social security numbers, again, something that would likely be encountered in your employee files. So if you get a request for a personnel record, you would have to go through that to determine if there's anything you can redact, and social security numbers must be redacted. Attorney-client privileged information. Any time that I send an email, email correspondence between your attorney and the director, between your attorney and the board, certainly any file correspondence would be privileged. If you have a question, often I write letters that say attorney-client privileged at the top. Sometimes we send emails that don't have that specific label on it, but it may be privileged anyway. If there's anything that is to or from your attorney, my recommendation is to have your attorney consulted before that information is released, because likely it will be subject to protection. Records that are exempt because the library and the requester are parties in a civil action. This is a really, really narrow exemption, and we were involved with a case that tried to kind of test the limits of it a while ago. This only applies to the party in the library. So let's just say a patron is suing the library over a dispute over their being suspended, their library privileges being suspended. That would be considered a civil action. If the patron sends a FOIA request asking for documents, and those documents are the same subject matter as the litigation, then certainly you can deny that request. However, if the patron's attorney or the patron's best friend or their spouse, for example, sends you a request, you have to respond to that. The court said that the party means party. It doesn't mean party's attorney or doesn't mean party's substitute or agent. So again, it's a very narrow request, exemption. When you send a denial letter, you must state the reason the document is exempt. An explanation can be given. And we don't have time in the session today to go through all of this in huge, great amount of detail, but some of the exemptions like privacy, and there's exemption for inter-office or agency communication. So something like the director may send a pretty frank letter to the board about a policy or about an issue. Some of that may be exempt, but there's also a balancing test that at times has to take place. You have to show that the public interest in non-disclosure outweighs the public interest in disclosure. And if one of those exemptions apply and that there's a balancing test, it's contained right in if you look at the Act, it's right there in the Act. It'll talk about that, weighing of the public interest, then the letter should really deal with that and explain why in this particular interest the public interest in non-disclosure rules the day. The written notice, and I get a lot of complaints for clients for this. The first time I send them, you know, kind of one of our form denial letters that has this, it has, the denial letters aren't form, but there's a form part of it that we put in there that whenever you deny either in whole or in part, that you have the right to seek administrative appeal or the right to seek judicial review, and you have the right to recover attorney's fees and damages if you prevail. So, you know, you actually have to tell the person, go ahead and, you know, you can sue us if you don't like our answer, and you can, you know, if we're wrong, you can recover attorney's fees. The reason we put that in there is that it is required by law. So something that should be in every. And that's one of the, I think that's the #2 mistake that I see libraries and other municipalities making, is they don't put that written notice in there, and then the requester can kind of use it against them. Failure to respond within the time limits or failure to respond at all actually amounts to a denial. So they're going to treat it as a denial, and if you, so what happens is if you know, if they sue you, if you don't respond and they sue you, and the lawsuit results in the library having to turn over that information, you may be subject to attorney's fees and damages as well. So that's another reason why it's very important within those time limits to respond. So going back to that example, you know, let's say you do call that person asking for an explanation, and you had every intention of actually giving them the money, or giving them the documents, I'm sorry, and they then you know, but you don't respond within the time period, and they sue you, and the documents ended up, you know, or ended up, you have to end up turning those documents over, you still may be subject to those attorney's fees and so forth. So it's very important that you do respond within that time period. And I just as an aside, there are some questions I have about fees, and we'll get into fees in just a minute, so we will get to those fee questions. You cannot deny a request simply because you've previously obtained identical records. Technically, I can send a letter to your library every day requesting the same information. Now, I'll be subject to the same fees every time I do it, but there's nothing that would prevent me from doing that. You also can't deny a request because the requester has not paid for requests that were previously made. So let's say I talked about the example of that client that had that, you know, reams of paper sitting on the desk for months. And that person never picked them up and never paid them, and they subsequently send you another FOIA request. You have to respond to that request. You cannot take, you know, say, well, you know, you didn't pay for the last one. And one of the things you can do is you can make them pay in full before you turn over the documents. That's one thing you can do. You can say, you know, we're going to grant your request, here are the documents, you have to pay us in full before we'll send them to you. That's reasonable. The Attorney General's office has said that's fine. But what you can't do is say, well, I'm not going to respond to your next request. Again, and you must send a notice denying the request even if you don't have the record. And that's one of those things that I actually had to send out a series of FOIA requests. Oh, it's been a while now. And one of the things that I thought was interesting, it was non-controversial, and it wasn't to libraries, it was to a bunch of townships, is that I got a lot of calls from township clerks that said, oh, we don't have the document. And, you know, it was nice. They got back to me right away, but they never sent me anything in writing, and technically that's a violation of the FOIA. So as another practice pointer, make sure that you send a denial in writing even if you don't have the document. Okay, getting to the fees. And the fees are actually a little bit complicated. So if you have questions about this, you know, certainly feel free to call me after the session to clarify it, or if you have any further concerns about maybe your particular library. But a public body, including a library, may charge a reasonable fee for providing a copy of a public record. It's going to be limited to the actual mailing costs or the actual incremental costs of duplication, including labor, and the costs of the search, examination, review, and separation of exempt information from non-exempt information. Okay? The labor fee is a little bit more complicated, and I'm going to discuss that in a little bit more detail. But again, the fee is to the actual mailing cost. So certainly postage. You know, the cost that you know, for the paper, you know, how much does it cost for you actually to you know, buy the paper? You can include the incremental cost of duplication, which would include, you know, the toner and all those fees. You're not required to do a cost study, but you should come up with a charge that's reasonable. You know, libraries are interesting. If you have you know, I don't know how many of you have public copiers anymore, but if you have a copier, if you charge for copy fees, certainly, and you charge, you know, 10 cents a copy for the people using a computer, but charge 20 cents a copy for the people who send FOIA requests, I think the courts are going to look at that. So kind of look at your overall costs, and if you have charges that you spend now, what you feel is reasonable, and make sure that they are coordinated for the cost of actually complying with a FOIA request. A public body cannot charge more than the hourly wage of a public body's lowest paid employee capable of retrieving that information. Okay, so if that person is, you know, your lowest paid employee that can do that, then certainly those are the charges that the hourly wage you should use. If your director is the only person that it can or your HR person, for example, is the only person that can reasonably go through employee files or something like that, then you can charge the hourly wage of that person. So again, it's just about keeping records and being able to justify the amount of the wage that you're charging, because again, fees can become part of the subject of litigation. Okay. So there's two types of labor charges, okay? And the easiest illustration is to say, okay, there's a labor charge for the actual costs of making the copies. So if I'm standing there, you know, and someone has handed me, let's just say they're for meeting minutes, for 3 years of meeting minutes, and I'm standing there and I'm actually physically making the copies, you can always charge those labor costs, okay? But if the labor is for the search, examination, review, or deletion and separation of exempt and non-exempt information, you can only charge those costs if the failure to charge a fee would reasonably result in an unreasonably high cost to the public body. Okay, and then so again they have a different standard. It must result in an unreasonably high cost. And two, the public body must establish and maintain procedures. Okay, so this is the only part of the act where you really do have to have something in writing to be able to charge that. There's many of different ways to handle it. You can take a look at other people's Freedom of Information Act policies. Many people don't really know about this, or it's not really that highly discussed. So if you know, certainly I would talk to your lawyer about dealing with this to make sure that you are, you know, on good legal footing to charge those types of fees, because certainly when you get your first huge FOIA request and it's going to take you 15 hours to do it, you want to be able to make sure that you are in position to charge those labor costs, because typically the labor costs of sitting at the copier and making the actual physical copies aren't going to be the majority of your labor costs. It's going to be the time that the director or the assistant director, you know, or one of your supervisors has to take out of their normal course of business to respond to these requests. If the party making a request submits an affidavit showing that, you know, they're receiving public assistance or unable to pay the cost, the public body must provide the records without charge up to $20. So you can kind of get an idea of where, you know, in the range the government at least thinks that, you know, up to $20, I don't think the government thinks it's that big of a deal to the public body because they've given this $20 limit. You know, but if you go back to the, you know, we kind of look as you go back to that provision that allows you to charge a deposit for $50. So if it's over $50, you can get it, you know, you can ask for a deposit. You know, it seems reasonable to interpret that the city or that the government, the legislature thought that $50 was significant enough of an expense to be able to recoup those costs. So kind of keep that in mind when you're talking about charging fees or, you know, putting together a policy for what you're going to charge for this labor for search, examination, review, or deletion. Again, this is we recommend that the library request that all fees be paid before the library actually turns over the records. You don't actually have to turn over the documents within those first 5 business days. All you have to do is respond. So as an example, what we would do is we would send out a letter that granted or granted in part a request. We would say, you know, we've granted your request for these types of records. The fee for your request is $25, for example. We will turn over the documents upon receipt of that fee. So again, you don't have to, you're not in obligation to, you know, go through and create all these and, you know, actually physically make a copy and send the copy of those records with the with the response. You just have you have an obligation to send out a response. Grant, deny, grant in part, and deny or part within those 5 business days. There is no fee recovery provision under FOIA. You would actually have to sue, either in small claims court or in civil, in circuit court, depending on the amount of it under a breach of contract theory. So again, that's why we make sure that you paid up front before you send those records in. I've drafted FOIA requests that have fees that are under $1 that must be paid before we turn over. Someone actually responded to a FOIA request I sent with, asking me for my 55 cents or whatever it was before I respond, and that's perfectly legitimate. Denials are subject to administrative appeals. You can deny, a requesting party may appeal a denial to the head of the public body. That's typically the library board. And again, unlike our original FOIA request that doesn't have to have any words, if you do an appeal, it specifically has to state the word appeal. Your obligation is within 10 days after receiving the appeal. You have to either reverse the denial or issue a written notice upholding the denial, or reverse in part and uphold in part. Again, just to point out, and I don't know why they did what they did, but this one is 10 days and not 10 business days. You can add an additional 10 business days under unusual circumstances, and so the unusual circumstances for appeals, that standard has been kept in the statute, unlike the original request, which you can get basically a 10 business day request upon notice. But this one you have to meet unusual circumstances exemption. A public body is considered to have received a written appeal on the first regularly scheduled meeting of the board following the submission of the appeal. And if you fail to respond to the appeal, the requesting party may seek judicial review of that in circuit court. It's typically been the case where they appeal to the public body first, but I want to say that we have seen a kind of an uptick in cases where they've gone right to circuit court. And oftentimes it's not with libraries, it's with other municipalities. Let's just say that there's a zoning dispute, they'll tack on a FOIA charge at the end if they feel you haven't responded to without seeking that administrative appeal. So it's one of those things that usually, like what we used to do before the statute changes, is that we used to deny it if we were we would deny it, and then you'd see an administrative appeal before it got to court. And you just don't see that all the time anymore. So keep that in mind when you're talking about denial. There were a couple questions I want to get to, because we're going to be going on to the Open Meetings Act section at this point. I think some of these I have already responded to, and I think that some of the questions, one of them was about a series of emails that's exchanged among the director and trustees commenting on a new policy. I want to deal with the email question during our Open Meetings Act question, because I want to point out something very interesting and very, I think, something that's really going to be, I think, a focus of future litigation. If the requester, and then the question is if the requester wants to review documents without paying for them. Again, this goes to the question, if that person asks, this does happen all the time where we say, look, it's going to cost you $50, we'll give you copies of this if it's $50. Sometimes the requester will come back and say, well, can I look at them before you make copies? And typically that is the good practice, is to allow them to do that. That's why we recommend that you send out the letter saying, the fee for your request is, $50. We will, send them to you upon receipt of that fee, because what that will do is, avoid, you having to actually physically make the copies first and incur that cost before you actually know that they're going to pay for it. So, again, if I haven't responded to these questions accurately, let me know. And one of the questions about what things you might redact from a personnel file. One of the ways to handle a personnel file, and that's a good example of how you kind of, as a matter of practice, would handle it. One thing I do when I get a request for a personnel file is I ask one of our employment lawyers to tell me what exactly constitutes a personnel file. So one of the things that we'll do is to go through the documents and make sure that it actually initially responds to the request. So if there's things in the personnel file that aren't technically part of the personnel file and shouldn't be in there, we might say, well, that falls outside the scope of the request. But that's one of the things you're going to have to do is, one, figure out if it's a public record, two, figure out if it's in the scope of the request, and then if it is, how do you respond? Certain things that we take out of the personnel file. One of the things, anything that would be medical. One of the 24 exemptions is for medical or psychological information. So anything that is arguably medical, we redact. I redact personal information that constitutes a breach of privacy. Anything that would if there's some, you wouldn't believe some of the things that people keep in files. It's not necessarily personnel files, but we have copies of like like canceled checks that have someone's bank account. Those types of things would all be deleted. And then also Social Security numbers. And when you respond to that request, what you would do is grant that in part and deny it in part. And we would say, for example, we grant your request for a personnel file in part. We'll send you the documents upon receipt of the fee. We've also denied it in part, and then cite every exemption that you need. A portion of the document has been exempt from disclosure because it contains Social Security numbers. We cite the section, we cite that. A portion of the record has, is exempt from disclosure because it reveals personal or medical facts, something to that effect. And then at the end we say, pursuant to Section 14 of the Freedom of Information Act, that we've redacted that information from, we've redacted the exempt information from the non-exempt information. And the exemptions are contained in Section 13 of the Act. It's MCL 15.243. I don't have them all in there because there's 24 exemptions and some of them have a significant case law attached to them. So one thing I do recommend is if you start to get FOIA requests, you may consider calling your attorney and getting some information on that to determine whether the exemptions are appropriate or not. All right, and I can handle some questions after that, but what I'm going to do is move on to the Open Meetings Act. If my slide will let me move on. Okay, I'm having a little bit of a there's a little bit of a technical glitch here, so I'm just going to go and start talking about that. And I apologize, we're running a little short on time, so I want to make sure I get to this. But the Open Meetings Act is something that here the violations again. I'm sorry, the violations you can result in civil action. We'll get to that a little bit, how that's a little different from the Open Meetings Act. The Open Meetings Act is something that I want you to keep in mind too in conjunction with the Freedom of Information Act, because sometimes they overlap, and we'll get to that a little bit later. But the Open Meetings Act was expressly enacted for the purpose of requiring certain meetings of the public body to be open to the public, to require notice in the keeping of minutes, and to provide for the enforcement of the act. Okay, and there are certain penalties for violation of the Open Meetings Act that are a little bit different than Freedom of Information Act. All meetings, and meeting has a particular definition, which we'll get to in a minute, subject to the Open Meetings Act, must be open to the public and held in a place generally available to the public. So if you are a city library, you can have your meeting anywhere in the city. You could probably have it in the neighboring city, but certainly don't, if you're in the Detroit area, don't have a meeting in Grand Rapids. It likely will not be considered a place available to the general public, because they're going to look at the general public as your constituents. Just a couple opening details. The Americans with Disabilities Act requires the library to provide disabled individuals with a reasonable opportunity to request necessary and reasonable auxiliary aids. Typically, every notice that we draft here at the firm and every notice that we recommend that our clients have has some sort of statement about the ADA and who can be contacted in order to obtain those reasonable auxiliary aids and services. A public body may not place conditions on attendance, such as requiring visitors to sign in or provide names. Okay, this is really important. There's a slight distinction. I know a lot of public bodies, and I'm just going to make a generalization here because I've attended a lot of library board meetings. I've also attended a lot of township and city meetings, and there, as a general matter, there's typically not the kind of attendance at library board meetings unless you have something that's, you have something that's really sparked the public interest, or something, happened at the library that's caused a lot of attention. But, your kind of routine meetings aren't you typically don't have standing room only. And so a lot of times those library meetings are handled in sort of, dealing with the public. It's more informal. And because of that, I want to make a statement about this, because in the event that you start to have an uptick in your attendance and you start to have people that come to every board meeting and people have lots of participation, I want to make sure that you know that a public body may not place conditions on attendance of the meetings. Okay, what that means is I should be able to come to your board meeting, walk in and sit in the back, and not have to ever tell anybody who I am or why I'm there. I have that kind of right to listen in private without identifying myself. There's a slight difference. If I want to speak, there can be some reasonable conditions on speaking. For example, the public body may require you to state your name and where you live. Okay, that's reasonable on making a comment. And the reason that that's a little different is if I get up and I say, I come to your library, and I say, I think this library needs to fix the way it does its internet policy. I don't like what I'm seeing on the internet. And you find out that I live 3 counties away. You may or may not take my comments with the same, significance as that you would if I, came to your library and was a citizen and paid taxes in your library district. So those are the types of conditions. You can't put conditions on actually attending the meeting. You can place reasonable conditions on speaking at the meeting. Okay. The right to attend a meeting includes the right to videotape or broadcast the public meetings. People videotape meetings all the time. I've had meetings where there's going to be litigation, so we've had actual court stenographers sitting in the front row writing down every word you're taking, and so that can be a little bit intimidating. But again, they have the right to record, videotape, and broadcast the meeting. There's a question about can they be obnoxious while videotaping it. You cannot breach the peace of the meeting, and that means disrupt the business. And a breach of peace would, include anytime you stop the meeting or, cause disruption so that the business of the meeting can't get on. So if someone's, they're, have a camera up the whole time, that's not a problem. You cannot prevent them from videotaping. If they're, standing in front of the board, I think it's reasonable to ask them to set their videotape and so forth to the side. I mean, those are some of the reasonable things you can discuss with your attorney. But again, videotaping, you can't shut down someone videotaping at the library board meeting. And I want to keep this in mind too, because we've developed for some libraries some videotaping in the library policies. We've had news crews that want to come in and take videotape, and because of library privacy issues, we've basically said you can't videotape unless you have the library board or library director's permission, for example. And it's a kind of a broad statement of the policy, but just as an example, make sure you exclude videotaping at the library. So again, if someone is at the public board meeting and they're videotaped, there's no expectation of privacy at a public board meeting like that. The people that are present at the meeting, if they're being videotaped, there's really nothing you can do about that. Again, if they're videotaping inside the library and the videotape, people are reading and doing, that's a different story. But at the public meeting, the right to videotape is right there. This is right out of the statute. And all persons in attendance at a public meeting have the right to address the public body. I want to make that, I want to keep that in mind because I've seen some library policies that limit the total time of public comment, for example, to 1/2 an hour. And that would likely be in violation of that provision. You can make reasonable limits on public speaking. You can, for example, limit anyone to a 3-minute time period in which they may speak, but you cannot limit the overall time period, because what that might actually do is prevent someone from being able to speak. If you have 20 people show up at your meeting and they each get their 3 minutes, that's going to be 60 minutes of speaking. It's going to, if you stop it after half the people have spoken, you're going to be violating the right of those people to speak at a public meeting for those who haven't had a chance to do it at that point. So again, if this becomes a problem, there's certain reasonable rules you can do to make sure that, one, people are not taking up too much time of the board business, that everyone's orderly, that they're speaking for the right amount of time, and people aren't just shouting out at every minute from the public gallery that, there's a time and a place for public comment. So again, library board meetings have tended to be a little bit more informal, the ones that I've been to, a little bit more dialogue with the people that do come to the meeting. But if it starts to become a problem for your library, it's pretty simple to get together reasonable rules and regulations for public comment provision. Again, I want to stress that typically what we do is limit it to 3 to 5 minutes. My recommendation is to not limit it to what they say. So, you can't tell someone that you're not going to cover that issue in the agenda tonight, so don't speak about it. I mean, they could get up and recite the phone book for 3 minutes if they wanted to. Again, it's the time, place, and manner restrictions, limiting the time of the speaking, not the substance of what they're speaking. Obviously, the Open Meetings Act, a meeting would apply to a library board meeting. I want to talk for a minute about committees and subcommittees, okay? There's a specific exemption for public bodies or committees or subcommittees that only have advisory authority, okay? They might not fit under the definition of a public body since they have no decision-making authority, okay? But what I want to talk a little bit about is that all committees and subcommittees are not created the same. I'll give you some examples because there's actually been quite a bit of litigation about this. And if a subcommittee or committee is actually narrowing choices and making like smaller decisions for the library board, then that committee or subcommittee is technically a public body in and of themselves and should be open to the subject to the Open Meetings Act. Okay, I'll give you an example. Let's say that the library board is looking for a new director, and the library board appoints a committee that's less than a quorum of the board. They have 2 board members and they have 3 other members of, they have, a couple members of staff and a couple members of the public, let's say, on this committee. And the charge of this committee is to, take all the applications in here and narrow it down to the top 4 to present to the board. The courts will say that that committee is actually a committee that is a quote-unquote public body under the definition, and it should be subject to the Open Meetings Act. That means, calling the meeting to order, taking minutes, making sure you're applying, acting within the confines of the Act. The reason is you're making decisions on behalf of that public body. By taking away the full realm of decisions from that library board, you are actually acting as your own public body. Taking that same example, let's say you receive 10 applications and your charge from the library board is to take all the applications, put them in a usable form, maybe make a chart of, different qualifications, and then present in, a recommendation. If what you're doing is taking all the information and handing all the information over to the library board and just maybe making an advisory recommendation, then likely you aren't subject to the Open Meetings Act. So these are almost the most difficult Open Meetings Act questions that I get. And when, if those of you that have worked with me on these kind of issues, it's really not something that I can say, okay, all, this type of committee or subject to the Open Meetings Act and these types of committees are not. You have to actually look at the particular committee, how it was formed, what they do, what they've been, charged to do by the library board or the director, and what are they actually doing. So those are the kinds of things that you should consider when you're talking about committees, and take a look at your committee system. If you're compliant with the Open Meetings Act, you typically don't have to worry about, but if none of your committees are subject to the Open Meetings Act, you may want to look at that again and determine if actually some of them should be open to the public. Because advisory committees are actually very narrow. There's most often the litigation involves these cases where the courts have found that these committees were actually making decisions on behalf of the public body. To be a meeting, the public body must be deliberating towards or rendering a decision on public policy. So again, committees that only have advisory authority may not fit within that definition since they have no decision-making authority. But again, getting back to the example with the personnel, if you're taking 50 applications and narrowing down to 4, you are actually making decisions on behalf of that library board and should likely be open to the public. So again, you quorum, deliberating and rendering a decision, and then a matter of public policy. One of the questions I got was about email, and there's actually been a lot of discussion on this topic. But I'll give you my opinion, and then you can take it how you will. But my concern with email is what I call the reply to all problem. Okay, let's just say that the director sends the library board the library director sends the library board a draft policy, let's say a patron behavior policy for them to consider. Okay, there's nothing inherently wrong with that. And let's just say that that goes out to the board members and none of them reply. That's fine. Well, let's take, for example, what happens if one person, let's just say it's a 7-member board, okay? One person hits the reply to all, says, well, I don't like, this policy that limits, the age of children to 14. I think it should be 8, okay? So, alone in the library. Again, probably not a problem. But what happens if 3 more people start talking by email about that same subject? Here you have a quorum of the board. You have 4 people, let's just say, talking about deliberating on a decision that's a matter of public policy. I think that sort of correspondence could be viewed as an illegal meeting, okay? It's going to be very fact-based. If one person makes a comment, I don't think it's a problem. But again, if it's a quorum of the board doing these sort of back and forth discussions, I think it's arguably a meeting that should have been held in public, okay? So the problem with this, and in conjunction when we talk about FOIA, is that now you have a written document that's subject to FOIA, discussions, often discussions between directors and board members can be subject to FOIA. There are some exceptions about that, but typically, a correspondence sending out a policy, arguably is subject to FOIA. So all that discussion is then right there. It's in, written form. It's preserved, something that can easily prove a violation of the Open Meetings Act. So that's why I really want you to be cautious when you're using email. It's such a wonderful way to communicate. It's very easy to do, but I think it's going to be sort of easy to trip yourself up and potentially get into problems. Now, there hasn't been a case in Michigan or in this jurisdiction that I'm aware of that really deals with that issue. I think it's going to really depend on what happens in that email exchange and who's involved and what you're talking about, okay? But because of the potentials there, and often you won't identify a violation until you're looking through documents or maybe until the violation's already occurred, I just want the library boards to be sensitive about it. In extreme situations, we've actually developed policies that say basically, for example, the director can send out communications and, and then, the policy is that you can get back directly with the director, but don't talk about the email or the email exchange among a quorum of the board. Another kind of easy fix is when you send out an email, blind copy the other people on it so that it's not that one click of the button to reply to all that can be a problem. Okay, so again, just to consider this when you're doing your communications, that this is a potential problem that I see out there and that could result in a violation. What is not considered a meeting? So we've talked about what is a meeting or what should be a meeting or what might be a meeting. What is not a meeting is it doesn't apply to a conference or informational gathering, provided that it does not involve deliberation and is not designed to circumvent the Act. So if a quorum of your board attends the Michigan Library Association conference in August and sits in a session, again, the gathering for a conference does not violate the Open Meetings Act. Don't sit there and start deliberating on business. Then you will be, in a position where you could be violating the Act. Also, informal gatherings. For example, if you're, find yourself at a cocktail party, with, a quorum of your board, one of you doesn't have to leave the party. But again, just use some common sense. Don't stand around and, talk about library business, because people, will see that, and likely it could be, constitute a violation if you're talking about library board policy at that cocktail party. I'll give you one example. A public body may convene to listen to the concerns of a neighborhood group without complying with the Open Meetings Act. Okay, again, so if you're sitting there listening to the, listening to the seminar or listening to a group of people, then not have to comply. You don't have to comply with the Open Meetings Act. I'll give you kind of an example, and I'll give you that I think happens a lot, and I'll tell you where I stand on it. And again, it's something I would ask your attorney about. But I get a lot of questions about having like these weekend training sessions for library board members. Okay, let's just say your board is having some problems, so you bring in an expert that deals with communication issues or something. If you just look at it on paper, and people are going to be attending and listening to a person talking about board issues, maybe a person talking about PR issues, that in and of itself is not going to be a violation of the Open Meetings Act. The problem I have with these sort of board retreat issues is that it's really going to start, if it's just the board, if you're in a conference room at a hotel, for example, you're naturally going to start talking about library policy in conjunction with what you're talking about. And so if that happens, then again, there's a possibility that you're violating the Open Meetings Act with that discussion. So, board conferences and those types of things, I generally recommend you open to the public so that you do have the ability to discuss board business and so forth. So again, that's one of those things that if you're in doubt, I would contact your lawyer, discuss what you plan on doing at those sessions, what you think should happen, and get some advice that way. I'm just going to briefly go over the notice. It's right from the Act. 10 days after the first regular meeting of the calendar fiscal year, you have to post a notice of the regular meetings. If you change those regular meetings, this is something that I think a lot of boards miss. You must post the new notice within 3 days after the meeting at which the change was made, or at least 18 hours before the rescheduled meeting. So if you change your regular meeting schedule, even if it's to change, meet in the third week instead of the second week in one of the months, again, post that within 3 business days, or within 3 days, I'm sorry, after the meeting. 18 hours notice for a special meeting. If you choose to recess for more than 36 hours, you only have to reconvene after you may only reconvene after posting the notice. So if you have a regular meeting, you recess it, you're going to meet again within 36 hours, you don't have to renotice it. If you're going to meet again after 36 hours, it has to be renoticed. Upon written request, the clerk must furnish a copy of the notice to any newspaper or radio. Special meetings require that the meeting be posted 18 hours in advance. There's a recent case on this that's kind of interesting because the way that the old case law works in the AG's opinion is that notice had to be posted and visible to the public within 18 hours. So for example, my recommendation was to post it on the front of your library, because if you post it on an internal board and your library is closed, you can't count those hours. Well, there's a recent Court of Appeals case that says that the statute doesn't require it be posted in public view for 18 hours, only that it's posted for 18 hours. So that's, I think, an interesting development. My recommendation in practice is to still post it where it can be visible for 18 hours, because I think that is certainly, if it's not a problem, it's you may be creating sort of a PR problem for yourself if you post a special meeting. Let's just say theoretically you post a special meeting notice on Saturday night for a Monday morning meeting, and you're closed on Sunday, and you do it on an internal board. Well, I think you're going to certainly have some issues with your public if you do that. So again, keep that in mind. A closed session, there's two separate procedural elements, and there's a number of ways you can go into closed session, and I'm going to talk about those. But I've broken them down in two separate categories, because a closed session may be called by a majority of the members present in the meeting for dismissal, suspension, discipline, complaints, charges, or periodic personnel evaluations of a public officer or employee, if the named person requests the hearing. One thing to note about this exemption, I want to talk a little bit about this exemption, because I think it's overused. I mean, I can't tell you how many times I've heard people tell me they've gone into closed session to discuss a personnel issue. And my next question is, well, what personnel issue? Okay, because if it's to consider the dismissal, suspension, discipline, or complaints against an employee or public officer, that's one thing. If you're going in to discuss a library director's contract, that's not covered by this exemption. So there's no general personnel exemption has to meet this specific exemption. So be careful about what you're doing with that. The biggest mistake that I see libraries making are, one, improperly using this exemption, and then two, having a motion that doesn't support what the exemption is. There's another aspect to that. The named person must request the closed hearing. So let's say that there was a complaint against the director of the library by a patron, okay, and the board wants to go into closed session to discuss it. They can only do that if the director requests the closed hearing, and then he or she can rescind that request at any time. Okay, so that's really important to know. Based on my research, and again, one of those things you should discuss with your attorney, there's no requirement that the person be allowed into the closed hearing. I mean, typically that's why you have the closed hearing, so you can kind of hear both sides of the complaint. But again, if you have, the only person that, unless there's a statutory exemption, the only people that are, by law required to be in that closed session are the library board members. Okay, the library board has the ability to invite other people in the closed session, and they can choose not to invite the person who is, being complained about into the closed session. Now, that may affect the person's ability or person's decision to have the closed session. They may say, well, if you're going to discuss me in closed session and I'm not going to be there to hear the charges brought against me, I want you now to discuss it in open session, in which that case that the library board would have to discuss it in the open session. You can talk about strategy or negotiation sessions in connection with a collective bargaining agreement if either party requests a closed session. Keep in mind that this involves active collective bargaining. It doesn't, if the bargaining has not begun, you can't use this exemption. This is, as another practice pointer, this is where I see a lot of violations that are, again, unintended. There's several exemptions, and there's more exemptions in the Act. Some of them apply only to, like, universities, and so I'm not covering those. I'm covering the ones that would apply to libraries. But a closed session may be called by 2/3 roll call vote of the members who are currently appointed and serving. Okay, that's important to know. So 2/3 roll call vote of the members appointed and serving. That means if you have a 7-member board, okay, 5 people have to approve the closed session before you can go in it. So if 4 people show up at your meeting, you're going to have a quorum. You could do library business unless your bylaws prevent you otherwise. But under typical majority of the board, for a 7-member board, 4 people would constitute a quorum. You still need 5 to go into closed session. I really make a special point of that because I have actually attended board meetings where I've been, called in as the attorney to discuss an attorney-client privilege communication, which you can talk about in closed session. I'll get to in a minute. And I get there, and somebody doesn't show up for the meeting, and so the library board has had me come for the meeting, and I can't discuss that information in closed session because you don't have enough members present. So really, one of the things to make sure you have the votes there before you call that closed session. You can go into closed session on this to consider the purchase or lease of real property up till the time an option to purchase is acquired. I want to point this out. You cannot use this exemption to go in to discuss the sale of real property, and there's a real policy reason behind it. As a public body, when you're negotiating the sale of property, you don't want to go in, in public meeting and say, oh, well, we're going to offer to purchase it for $100,000. Someone attends the meeting, they offer the seller $105,000. You shouldn't have to show your cards like that, and that's what the legislature has done. Okay, the opposite is not true. If you want to sell it to somebody for $100,000, and if a member of the public hears that and says, well, I'll buy the library property for $105,000, again, the interest is for the library is to get the best price for that property, and so that's why discussion in public is required in that situation. You can discuss with your with your attorney regarding trial or settlement strategy in connection with specific pending litigation. Again, this is specific pending litigation. It's not prospective litigation. If you think someone's going to sue you, you cannot use this to go into closed session. You actually have to have a specific lawsuit that has already been filed. Similarly, if you've settle the case, if you have a settlement agreement and an issue comes up with the interpretation of the settlement agreement, you cannot use this to go into closed session to talk about a case that's already concluded. The merits of it have already concluded. So again, make sure And then the municipal attorney actually has to attend this closed session with you. To consider material exempt from discussion or disclosure by state or federal statute. I want to bring up 2 points where libraries will use this quite a bit. One is to discuss attorney-client privileged communication. You can go into closed session to discuss attorney-client privileged communication. So if you get a letter from your lawyer that's subject to privilege, you can go inside to discuss it. You can only discuss the legal advice that's contained in that letter. You cannot use that as a jumping off point to discuss general policy. Okay, so just be very careful about that. The second place where you'll see this exemption coming up is when you talk about the Library Privacy Act. And we are very careful about this when we talk about patrons, and this comes up a lot when you have appeals hearings. Let's say you have a patron who has been you know, banned from the library for a certain period of time, and they take advantage of your appeal provision, which should be in your personnel, your patron behavior policy, and they go to the library board to appeal their suspension. My recommendation to the boards is to be very careful about how this how that material is handled. We go into closed session to discuss those library records. Okay, so anything, you know, the director's report on the incident report, all those documents, you can discuss that in closed session, and it should not be discussed in open session. Typically, we label the patron, we call them patron, 2011-1 complaint, so that it's not known at the public meeting who the patron even is, or certainly what the circumstances are behind the suspension. And the reason you want to do that is, there's an example of a case that we handled that involves a suspension, and one of the counts charged against the library was defamation. Well, the library could honestly say, no, there was no time or place where this person's name was ever mentioned in public. So the defamation count basically was, goes out the window. So again, be very careful about that. Consider specific contents of an application for employment. This is really, really narrow exemption. I don't want to go into it very much, but it's basically if the candidate requests that the application remain confidential, and you can only go in to discuss the specific contents of an application. You can't go into closed session to compare applicants' applications. I think the basic policy behind this is that it's almost like one of those first round applications to make sure that that person meets the qualifications of the of the job position, so that in a public setting you're not opening these prospective employees for public consumption, or their so their current job will know if they're not even going to make the first cut. So again, if you're going to use this exemption, I would get some clarification from your attorney that it's an acceptable use. The closed session must be preceded by a vote in open session, and the roll call and the purpose of the closed session must be stated and included in the minutes. Again, make sure you get this accurate, because this is one of those subjects of litigation I see quite a bit. So again, if you're talking about this personnel evaluation or personnel complaint, make sure that the motion states to hear a complaint made against the person, and if that person is not present at the meeting, make sure that you get something in writing from them that says you want it to be in closed session, and put that in the minutes and in the motion. And if the person is present at the meeting, make sure it's on record that that person requested the closed session. At the conclusion of the closed session, a roll call. At the conclusion of the closed session, you can have a roll call vote to close the session and reopen the session. But I say roll call. It's the safest thing. The statute doesn't really address it. But again, just make a motion to go into the open, to close the closed session and reopen the open session. All decisions of a public body must be made in an open meeting. No decision may be rendered in closed session. Okay. There has been recent litigation over this too, about how exactly you do this. So be very careful, and you might want to discuss this with your attorney. But if there's nothing that kind of makes me cringe more when I get a call from somebody that says, yeah, in closed session we decided this. Well, technically there's no decisions that are made in closed session. So, and you have to be very careful, because if you're discussing attorney-client privileged advice, you don't want to reveal that advice in open session too. So there may be some specific way you want to think of in advance to craft that motion that's made after the closed session. I'll give you an example of this litigation that I was speaking of. The court was found to be in violation of the Open Meetings Act because what they did was they discussed settlement of a lawsuit in closed session. And I think they kind of discussed what the terms would be in closed session, and the lawyer made a recommendation because the lawyer was in there. So when they went out of closed session and back into open session, they basically instructed the lawyer to put the settlement terms into, reduced them into writing. But what the court found was that nowhere in the open record did it say we've decided to settle the case, pursuant to the terms discussed in closed session or something like that. So the court found that there was a violation. So this gets very confusing, and it's kind of, you kind of have to evaluate it on a case-by-case basis. So if you're going into closed session and that discussion is going to result in a decision made in open session, think about how you want to say that and how that should be handled, before the meeting. The director or the board president may want to discuss this with the attorney so that you can have some guidelines of what you can and can't do in the closed session and then the resulting open session. Often I will draft an attorney-client privileged communication, and in that communication I will give a recommendation. And so when the library board moves out into open session, they may make a motion that makes it clear that, that directs me to follow the recommendation as, made in the letter in closed session without discussing the contents of it. Again, those are kind of case-by-case decisions that you should be making, but be very cognizant of that you're not making the decisions in closed session, and then, make sure you think about what will happen in open session. The only topic of discussion in closed session is the one that's authorized under the Open Meetings Act. So again, you have to kind of have a monitor in the closed session. Certainly, don't get off topic. Don't start discussing, your internet use policy if you've gone into closed session to discuss, a legal issue involved with, a patron behavior policy or something like that. Don't get off topic. We're kind of running short on time, so I want to make sure we have a couple more slides. I'm not going to really go over the open session minutes. It's pretty self-explanatory. This slide tells you what must be included. There's a minimum of what must be included in the minutes. Certainly all motions, any roll call votes, decision makers. Whether you do do like a verbatim transcript of the minutes or whether you do something more cursory is sort of up to the public body outside of these specific legal requirements. One thing I want to point out, closed session minutes have to have a separate clerk or designated secretary. That you can only disclose closed session minutes if a civil action's been filed, so don't disclose what happened in closed session. Testimony that occurs in a closed session becomes part of the minutes, so don't talk about what happened in closed session verbally after that. It's going to be a violation of the Open Meetings Act. Closed session minutes kept a year and a day. So again, no discussion. Caution people before every closed session that they can't take any of the documents or any of the discussion out of closed session without risking the violation of the Act. Remedies. There's a couple remedies. A decision can be invalidated. You can be charged with enjoined from further noncompliance. I want to point out this middle bullet point. If you do make a mistake, there is an ability to reenact the dispute. Sometimes, but the reenactment is effective from the date of the reenactment, so if you've got some timing issues, you should be careful about whether you reenact it or don't reenact it. And but again, I think that the legislature wanted the ability for public bodies to make honest mistakes and be able to fix them, because again, like I said in the beginning, mistakes are made with the Open Meetings Act. I mean, most of the people that, especially on library boards, are volunteers. This is their volunteer job. They're doing it at night. And on weekends they've got full-time jobs. You're not expected to know, every in and out of the Open Meetings Act. A lot of it's unintentional, and I think this really goes to the fact that the legislature understands that and has the ability to reenact that. The problem is if you intentionally violate the Act, you could be held personally liable for actual attorney's fees and $500 damages. And you also could be guilty of a misdemeanor. So be really careful. A lot of, if you have I just don't see that this much. I mean, most of the actions I see are unintentional, but if you know that you're violating the Open Meetings Act and you do it anyway, you could be subject to both civil and criminal penalties. So be careful about that. Anyway, I know there's some questions, and I didn't get to all of them, and I apologize. And I see them, and I'm going to respond to them after the session. So certainly you have my email address. If there's something I didn't cover, then let me know. Or if you have questions, please contact me. I'd be happy to clarify it. And thank you very much. I know it's another hour and a half of me talking consistently, so I really appreciate the audience, and we will look forward to doing